So Lizzie Troughton is a legal officer for ADF International based in London in the UK. Before joining ADF International, she was an international consultant advising global institutions on regulatory and compliance matters, and worked also in legal capacity at the UK Ministry of Justice and the World Health Organization. She has a law degree and an LLM in international law and human rights from Warwick University, and a master's in socio-legal studies from the University of Nottingham. Lizzie, I'm very eager to hear what you have to say. Please, Lizzie, share with us your experience and your remarks. Thank you.
Thank you, Mike. It's good to join you today. I also have a presentation, so I'll just try and share my screen. As Mike said, I'm based in the UK. Our office is in London, and so we work in Westminster, and we're a small team here in the UK with ADF UK. We work with parliamentarians mostly, and we provide legal advice, and we work on policy. So today I'm going to be talking about a very UK-centric idea about home education. We call it elective home education here instead of homeschooling. And you may be aware that in the UK we have 4 nations. England is one of them, and the education law is different across all the nations. So I'm going to be focusing specifically on England. We have worked with Welsh law as well, but today I'll just be looking at England. So just as a bit of general background before I go into the case where a judgment was delivered this week, which will be of interest to everyone. The law here in England is a little bit complex on the education side. We have legislation itself. The statutory basis for home education says that parents can home educate as a viable option instead of sending a child to school. And they must do so in accordance with an education that is suitable, and that has to be suitable to a child's age, ability, aptitude, and any special educational needs. We've also got the Children Act and pupil registration regulations, and there are a few other smaller pieces of law that govern how home education is regulated in the UK. That provides both the duties for parents, as I've said, but also duties for the local authority. Now, the way that our system is set up here is that we have national law, and then we also have delegated law or delegated authority to local authorities. So they're the specific parts or the counties, as you were, around England. And the local authority can have a lot of responsibility in looking after children and looking after safeguarding needs of children. So I've referenced here section SAO, that refers to a school attendance order. So that means that if a local authority is aware that a child is not receiving suitable education that the parent must provide, they can say, parent, you must send your child to school. They also have other duties to respond if they are aware of safeguarding issues. So for example, if the child is at harm within the home. Then we move on to the slightly more complex area, and that is regulation and guidance. So as you can see here at the very top, we have statutory guidance. The Department for Education has written out what local authorities must do related to home education and related to children not in school. The statutory guidance is from 2016, and it's primarily about safeguarding, but it links home education to safeguarding in that. And then we've also got non-statutory guidance. Now, this was again written by the Department for Education. It is not as binding, but it still kind of gives a landscape for what local authorities and parents must do, or ought to do rather, in home education. And then to the right, we have case law. Case law is relatively thin here in England regarding home education. Very few cases that we can actually mention. So the first one on the list is the Joy Baker case. And you might have heard of Joy Baker. She's really held up in the home education community as a hero. Back in the 1950s, she started about a 10-year court process where she said education otherwise in the law, i.e. the law at the time, the 1944 Act, said that children could be in school or otherwise. She said that that should mean home education. And she had a long legal battle on her hand, and eventually she won the case. And she's really heralded as somebody who fought for the right for children to be home educated. After that, we have a couple more cases, and in these cases, there were very specific areas of law that were being looked at. And I'll just draw your attention to the fact that the last of those cases is in 1985. After that, there hasn't been much interaction with the courts and home education, but we have had new pieces of law, and we've had statutory and non-statutory guidance. So up until this year, I'd say that most of our law regarding home education in England relied upon the text of statute, which is quite minimal. It basically says that education needs to be suitable, and if not, then the local authority can step in, or it's been laid out in statutory or non-statutory guidance, which kind of gives authorities powers to intervene. The other thing I'd say is that there's a grey box down here. Now, this is looking to the future. So there have been recommendations over around the last 10 years or so that there is more regulation in home education, so that families are taken a closer look at by local authorities or by the state. And this is very pertinent at the moment because there are some current recommendations by Parliament to introduce a register for home educated children. Previously, parents do not need to let the state know if they're home educating if they do it from scratch. And also they have recommended in-person assessments. And this is obviously going to be very significant for all the home educating families in the UK. And there's an opportunity now to be able to engage with policymakers to try and stop the ramifications of those recommendations being so bad. But that gives the background. And I take your attention to this case of Goodred in 2021. And this is what I'm just going to talk about here. So this is the Portsmouth City Council case. I've written out a timeline here, and this is very significant. The judgment only came out 2 days ago. So we're still trying to process what it means and the ramifications for the home education community. But suffice to say that it really will be significant in how we understand the role of the local authority and how it can intervene in every family's life and can look at the education provided. So the timeline is this. Last July in 2020, a family was asked to provide evidence about how they were educating their 3 children. Now, a lot of home educating families in England and across the UK have taken it upon themselves to think of themselves as the owner of what this means, what is a suitable education. And indeed, it hasn't really been contested much, but Portsmouth City Council, and Portsmouth is an area in the south of England, that were given this authority by the national government to be able to decide really how they handled home education. They asked for samples of work. So the family said, actually, we're not going to provide you samples of our work, but we're going to tell you how we're educating our children, because we think that there's latitude within the guidance to just tell you what we're doing and to say that is suitable and our children are progressing well. And the council said, that's not good enough. We want to find out more information. The way that the council are able to do this is because in the guidance, it talks about an exchange of information between the council and parents, but it leaves it as a very grey area. So it says that the council can ask questions or can make informal inquiries if they want to find out whether education is suitable. The aim of that is either to ask the child to be put in school if there's really poor education provided, or that they could trigger some safeguarding arrangements if they feel that the child is at risk. But that wasn't really clarified. So the family said, we don't want to provide any more information, and they submitted a complaint about it. And then eventually, if we come forward here to 2021, at the very start of this year, the local authority, the Portsmouth City Council, said, we're not satisfied that you're providing suitable education, and therefore we're going to impose an order on you to send your children to school. The family wanted to contest this, and so they sent a letter before action basically saying, we'll take you to court if you don't respond to us. And then here in February, a judicial review claim was issued. Now, this means that the family lodged the claim with the court, and a judicial review is asking the court to see whether the local authority has been lawful or unlawful in what it has done. We fast forward to the 18th of October, and the case was heard in the High Court. And that's not the highest court in the land. There are still two other courts above it, but that's the court that generally deals with these matters where the local authority is questioned on its lawfulness. And then the judgment was handed down 2 days ago. You can see that it gathered some media attention here in the BBC and on national news. And it was really spoken about as a David against Goliath moment, the small home educators versus the large council. So what happened as a result? Well, the judgment was not favourable to the home education family. The family was arguing that they had more latitude under the guidance to be able to say, we are the final determiners of what is a suitable education. The local authority was saying, actually, we want you to be able to prove that to us. And that was where the basis of the argument was. And what the judge said was that actually that wasn't unlawful for the local authority to make those inquiries. The family had said, actually, your guidance is unlawful because you shouldn't have to ask for us for very specific examples. You shouldn't have to ask us to show progress, because in this country, we're free to be able to choose what curriculum we teach our children. We're free to be able to choose how our child progresses, to use whatever pedagogical methods we want to use. But that was contested, and the judge fell on the side of the local authority. Importantly, the judge said that there was a large margin of discretion for the local authority. This has really large ramifications. I'm going to stop sharing my screen here and basically talk about the impacts of this case, because the judge used certain case law to be able to say that there's a large margin of discretion. And it chose a very extreme example of a case to use where a public interest test was stated. So there are some matters here that really need to be clarified. It's unknown whether the case will be appealed. It's likely that it won't be appealed. The reason is because there's no specific area of law that can be challenged. The judge was in essence looking at a grey area of guidance. And it was saying that in this grey area where the local authority has some duties and the family has some duties, we're going to fall on the side of the local authority. We think that that was reasonable. And so there are certain issues that arise, questions that need to be dealt with later. And it is our job now to figure out whether that should be contested in a court of law, whether that would be helpful, or whether, like in this case, it wouldn't be helpful for the home education cause. So we're going to be looking at, can the state say we would like in-person assessments with children? That's been proposed and it's currently unclear. It's not in the guidance. Can the state say there has to be a certain level of academic achievement and progress? Or can the parents say, we want to decide what academic progress actually means? Can the state say there is a purpose for education that has to fulfill these certain aims, for example, a social good? In our schooling system, children now have to learn about British values and becoming a citizen, and all of these socialization matters. Is the same for home education. These things are unknown, and the judge has not answered these questions. And the final thing is, how much discretion does a local authority have? how much discretion between one local authority and another local authority to intervene into the rights of homes. The judge didn't seem to answer that, but he just gave it a wide margin. So there's lots of issues that fall out from this case, lots of unanswered questions. The next stage is to think, how can we strategically engage? How is it best for home educators in the UK to engage with this? Where a system of law has largely been built on guidance, is it right for home educators to go to court to challenge the guidance? Or does that expose them to risk? As Lorcan said, did this case potentially not have the best facts because the family were not choosing to fully engage with the local authority, when perhaps providing samples of work may have satisfied the local authority and then may have made them retreat, and then the family wouldn't now need to send their children to school. And also the question is funding. In this case, a lot of home education families gave money over, and they raised almost £40,000. And to take the case further, they'd need a lot more money. So thinking strategically as a group of home educators will be really important as to what is worth pursuing next. Of course, on top of that, I had the grey box at the beginning saying there are proposals to bring in a register and assessments in the home. Now, is it best placed for us to look at influencing policy and guidance before this comes into law? And that's an area for the home education community and lawyers to be able to engage with next. So I leave a lot of questions at the end of today. A bad judgment. The impacts of that are unknown. The Department for Education is yet to produce a statement on how this may impact their guidance. The local authority is yet to produce a statement on what they will do as well with other families as a result of this. So we await that space, but in England, we have a fight on our hands over the next few upcoming years. So we'd appreciate your thoughts and your prayers on that. Thank you.